Hi, everybody. Welcome to Trial Alchemy. And today I'm delighted to have as my guest Edward, but he goes by Skip Babbitt. Skip has been practicing law here in San Diego since 1985. And he started out, as many people do, I did the same thing, started out doing insurance defense work with a very fine firm in San Diego. And then after a number of years, starting in 1997, he decided to become a sole practitioner and has done exclusively personal injury plaintiff work since then. And Skip has extensive trial experience. He has tried more than 53 jury trials, 12 bench trials, over 2,000 mediation arbitration hearings, and tons and tons of negotiations and settlement conferences. Now he's been awarded numerous awards for his outstanding results over the years. In 2007 and 2013, Skip received the Consumer Attorneys of San Diego Outstanding Trial Lawyer Award. And in 2014, he received the Consumer Attorneys of San Diego Consumer Advocate of the Year Award. So all of these are great signs of outstanding trial results. Now in San Diego, we've got an entity called the San Diego Inn of Court. It teaches young lawyers how to try cases, and Skip served on the board, also served as an instructor. I've done that in the past and a demonstrator. And Skip was the president 2012. And he also served on the as the education committee chair for many years for the Consumer Attorneys of San Diego. And in 2012, Skip was admitted to ABOTA and has been an active member of the San Diego chapter ever since. So, Skip, without any further ado, welcome and thanks for being a guest today on Trial Alchemy.
Glad to be here, Monty. Glad to be here.
Great to have you. Well, let's start off with this question. And I like to start off with this, and that is
Hit me.
tell me about one of your most satisfying trial victories in the numerous trials you've had over the years.
2006, I had a case venued out of Stockton, California, Central Valley. Good, what, 400 miles away from here in San Diego. Most of my client's treatment was in the San Bernardino and LA area. He had a
Mm.
back injury. He was a truck driver, just real short. He was a truck driver. He was in a truck stop in Lodi, California, and near Stockton. He was sitting in the fueling lane. He had unstrapped himself. He was doing his logbook stuff. Another truck driver had gotten into a fight in the restaurant, spilled out in the parking lot. He got into his Peterbilt and tried to leave the truck stop real fast by going out the entrance. Right as he's nailing it, trying to go out the entrance, another truck's coming in. He swerves his truck. He hits the rear trailer of my guy's truck who's sitting there in the fuel line. My guy, who happens to be about 5'7", 320 pounds, bounces out of the seat upside down into the passenger compartment due to the whiplashing effect of the trailers going back and forth like this, being hit by
Wow.
the. He has a back injury. He ends up getting a lumbar fusion. Um, and the insurance company for the trucking company that caused this whole thing, they were out of Oregon. Um, the insurance company is saying, oh, he had pre-existing degenerative back condition disease, which he did at his age and his weight and stuff, and all of his back problems are due to his weight, not from this accident. And we have a biomechanical engineer that can say he couldn't have been hurt in this accident. The forces would have been like stepping off of a curve that day. Here we're offering you $15,000.
Big money.
Big money. You know, all of his treatment was through workers' comp because he was on the job at the time. But still, the medical bills totaled over $150,000 in
Mm.
workers' comp.
Yeah.
And he was disabled as a truck driver. He couldn't work as a truck driver ever again. And he left high school in 11th grade to become a truck driver, get his Class A license and whatever. That's all he knew. He was about 48 at this time. So they're offering us $15,000. And obviously we can't take it. I do a 998 just out of the blue for 150. saying, let's see if I can get working them up a little bit. They don't even respond. I have to take 10 experts from the San Bernardino and LA area, medical doctors, economists, my own biomechanical engineer. I've got to take 10 experts to Stockton for trial.
Pricey.
So, you know, think about 10 grand each.
Yeah.
Let me put it this way. I'm going to trial with $150,000 demand, which it had expired, but I knew we wanted a lot more because it couldn't drive the truck anymore, it's disabled. I'm taking a case of trial in Stockton with 10 experts that are costing me anywhere from 6 to 10 grand each to appear. I had to take all of their experts. They had 6 experts, and I had to depose all their experts all over Northern Cal. By the time we went to trial, I had close to $180,000 my own money in this case, knowing my client could not pay me back if we lost this thing. This
Right.
is the risk. This is the gamble we take. You know, playing blackjack at a $25 table is not gambling. That's just pennies. What I do going to trial in a situation like this, that's gambling. That's
That
how
is.
it's poker. So in any event, we do a 3-week jury trial. The defense attorney is a senior attorney at a firm out of San Francisco called Low, Ball, and Lynch. Kid you not, that is their name, Low, Ball, and Lynch. And the defense attorney was one of these guys, kind of short, probably early 60s, bald, red face, no fingernails because he chews his fingernails. He looks like the type of guy that probably wears the gray suit, white shirt, red tie on Christmas morning when he wakes up with his kids. If you can picture what I'm giving you here as a visual. And he was just nasty the whole time, stipulate to nothing, he said he unilaterally set my expert dates and say, if you move them, I'm going to move the court to exclude them for not testifying. And I mean, we went through every dog and show on this. In any event, it was a 3-week jury trial in Stockton, California. And I had to fly all my experts up there to Sacramento, get them rental cars, hour-and-a-half drive south to Stockton to testify for however long, and then send them back home. So anyway, it was a 3-week trial. We're in Stockton. We're at the Howard Johnson's about 3 blocks away during this whole time. Trial's over on like Thursday afternoon, about 2 o'clock, 2:30. We walk the 3 blocks back to the courthouse, and I tell my client, I gave it everything I got. You got the best I got. The only promise I make to my clients is you will get the best that I got. It's the only promise I make. So anyway, we walk back, strip down. It's hot. It's summertime. It's hot. Turn on the swamp cooler in the Howard Johnson hotel room. My client's in the room next to me. My client had been living off of Vicodin and Bud Lights like the whole trial, as well as probably 2 years beforehand. I mean, he had a bottle of Vicodin, like this was 2006 to get this stuff there. Get it now. A bottle of Vicodin, he must have had, 200, 300 tabs in there. And he just lived off of Vicodin and Bud Light. So we get back to the hotel room. And before he goes in his room, I said, dude, I'm wasted right now. At the end of a jury trial, you decompress. You've handed it over to the jury, your whole case over to the jury to make a decision and decide. And you walk back and you're just totally numb. Your brain has been going 1,000 miles an hour for the last month and a half, and all of a sudden it is a sudden zero. And I remember we get to the hotel room and I was just done. I was just done. Brain was just shutting down. Body was shutting down. I hurt all over.
You were having your adrenaline crash.
Exactly, Monty. And I kiddingly tell my client, and I'm diabetic, so I don't drink. But I said, give me 2 of those Vicodin and a Bud Light, man. I need it. And he goes, no problem, Skip, no problem. So, of course, he gives me 2 Vicodin and a Bud Light. I go in my room, turn on the swamp cooler, like I said, strip down to my skivvies, and I'm laying on the bed watching the local Stockton news, and the Bud Light and the Vicodin have started kicking in. My cell phone rings.
Oh, no.
It's the court. We are literally 42 minutes out of that courtroom when my cell phone rings.
You're a little nervous.
Court clerk says, Mr. Babbitt, you need to come back to the courthouse. I said, jury got a question? She goes, no, they got a verdict. Okay. Now, the Vicodin and the Bud Light are really kicking in on this non-drinker, non-drug user guy. You know what I mean? So I knock on my client's wall because his wall was room, and I bang on his wall and I said, Don, you got to get up. We got to dress up. They got a verdict. Let's go. Let's go. Get back clothes back on. So we suit back up and we're walking that 3 blocks back to the courthouse. And I'm trying to explain to my client that generally when a jury comes in after a 3 week trial in like 45 minutes, not a good thing for the plaintiff. The odds are usually not good for me.
Yeah, you were telling him, like we all know who've tried cases, and you've been on the defense side too. You get a verdict in an hour less, likely a defense verdict.
Likely a defense verdict.
Yep.
So I'm trying to explain this no matter what happens, Don. We win, we lose. We don't cheer and we don't cry in the courtroom. We save
Yep.
it and keep it all inside of us until we get outside into the parking lot or whatever. Then we yell and scream or cry and hug or whatever it is, but we don't split express it in the courtroom. That's just kind of one of my general rules.
Yep.
Whether you win or you lose, it just looks bad to get too emotional on something like that. So he goes,
I've always agreed with that approach. Yeah,
I'm sorry.
I agree with that approach.
So we get in the courtroom, sit down, and you get to the courtroom, and it takes about another 20 minutes for the judge to like get the jury, telling you the jury there, and you just, on
Yeah.
his seat, just, and I'm sitting there, doing that, and then the jury comes in, they sit down, and the judge tells the clerk, please hand me the verdict, and says, Mr. Foreman, is this your verdict? Yeah, this is our verdict. Judges, it's like 3 pages long. And like the judge is like going through the first page for about 45 seconds, seems like an hour. He goes to the second page, same thing. And this is just like pins and needles to the nth degree, Monty. I think you understand. It seems like it takes them forever to
Yeah.
read the 5 questions on the
You
damn
can't you
verdict.
can't wait and you're dying.
Exactly. And he says, okay, verdict seems to be in order. Madam Clerk, will you read the verdict into the record? So he hands it to her, and it was a $1.2 million verdict
Outstanding.
in less than an hour. Now, the defense attorney definitely did not know the rule I knew, and I applied by. He stood up, he banged his hand on the table, he started yelling, he started looking at the jury to the point where, and he started talking about, how could you people have done this? Da, da, da. The judge had to shut him down,
Wow.
and and the whole thing, and whatever. And he just lit up and yelling and screaming and bouncing around and da da da. Now, I'd asked for 2.5 million, and I thought the case was worth it. I really did.
Yeah.
1.2 is still a pretty damn good verdict facing a $15,000 offer going to trial. Do you know what
I
I mean?
think it's an excellent verdict. Yeah.
And for some reason, though, the whole trip back home, 8 hour drive from Stockton back to San Diego, because I had to pack up everything in my truck that I had. And I'm beating myself up. Why didn't they offer me give me 2.5 million? I thought I proved that whole point. I thought I proved that whole case. And I'm on the phone to my wife the whole way back. I'm on the phone to my secretary the whole way back. I can't believe it. I thought I did better. And I finally got back, and my secretary told me, says, Skip, you got $1.2 million on a case out of Stockton. And I started thinking about it. On that jury panel, the highest wage earner we had was like 14, 15 bucks an hour. You know what I mean?
Yeah.
It was very, whatever. And what I find in counties like that and jury pools like that, it used to be this way when we did civil trials in the South Bay. Those people think $10,000 is a ton of money,
Right.
and it's not. When you got debilitating injuries or whatever, they think that's a lot of money. So to get even 1.2 out of this jury out of Stockton, that was probably one of my most savored victories of a jury trial, especially when I took on this firm, Low Ball and Lynch, and their senior partner there. Now, the epilogue to this whole story, which is kind of funny, is Low Ball and Lynch puts out a monthly newsletter, a little pamphlet thing, and colored and all nice. And for some reason, I got on their mailing list, a year and a half into this case, so I was getting these every month type of thing. And a month after this trial, I get their Low Ball and Lynch newsletter thing, and it's telling what a great victory this guy Ray Coates, the defense attorney, got in this trial out of Stockton because the attorney, and they fluffed it off. The attorney was asking for $6 million, and it only came in at $1.2 million. And I wanted to respond. I wanted to say something, but you just let that stuff go. You know what I mean?
Right.
I, I knew what happened. The defense attorney knew what happened. So anyway, as far as victories go, that was one of my most satisfying victories.
Well, that's a great result. And, that's a tough venue for the plaintiff. And you got people, like you say, they're not making a lot of money. And you got a hell of a result on a case where they offered you a whopping $15,000.
Arnold Schwarzenegger was governor at that time. People are coming in with their Schwarzenegger T-shirts on. Do you know what I mean? I'm thinking, oh man, this is the wrong jurisdiction for me, But it came out. What it was is they were salt of the earth people. My client was a truck driver. They fully understood.
Yeah.
They fully understood. They got it. And it was one of those trials that taught me, and this back in 2000 taught me, these people get it. The jurors get it. We always think we got to repeat things or go over things, or maybe these medical issues are too complicated. They get it. Yeah, most of these people are highly intelligent, no matter what their walk of life is, and they understand and they get it. You show them disability. I had my client do some things right in the middle of the courtroom there, during the trial.
Yeah.
Bend over, touch your toes. I mean, can't do that. All through the trial, he had to get up and stand in the back of the trial against one of the columns because his back was just hurting so bad. And I had to explain that to the court as well as the jury before the trial started, that my client's going to get up and leave occasionally, maybe stand in the back, maybe go walk around the court because he's got back issues. Of course, the defense attorney just lit up when I said that. Oh, he's prejudicing my case right already, So anyway, one of those cases, everything was a fight with that defense attorney, every single thing.
Yeah.
And how do I put this? I filed 4 motion eliminates in that case. He filed 32 motion eliminates.
So typical for the defense side. Yeah.
No, 32 motion eliminates on nothings, on
Yeah.
nothing. You know what I mean?
Well, now, Skip, you say your client was living off of some beer and some medication.
Bud Light Vicodin, man.
Vicodin, but one of the great benefits when you're the plaintiff's lawyer, and I'm sure you had in this case, is I'm sure you made a tremendous difference in the life of your client by fighting for him and getting that result to help him go through his life and deal with his pain. Doesn't that give you a lot of satisfaction, maybe even more than the win in the courtroom that you made a difference?
Absolutely. Absolutely. And that is the backstory of all of our cases is I mean, I put close to $600,000 cash tax free in this guy's pocket at the end of the day. You know what I mean?
Yeah.
And it changed his whole life. He went back to school. He stayed in contact with me for about a year afterwards. Some clients do that, some clients don't, but stayed in contact with me. He went back to school, got some type of computer degree or whatever. His marriage hadn't been going well at all, and he got a divorce, found a new woman that he was very happy with, and whatever. And his life, yes, just like you said, his life was better, and he, despite all that, he still missed being a truck driver. He loved driving the trucks,
Oh,
and
I'm sure he did.
yeah, he
Yeah,
did. He just loved it. So, but
I'm
no,
sure he did.
his life
Well,
improved significantly.
well, let me ask you about this. You've tried a lot of cases, and that was a great example of a case with an outstanding result. And there's a lot of work that you have to do to get ready for trial. And I'm sure over the years you developed your own approach and system. But when you're in that final trial preparation mode, I don't know whether it's a month before or however, whenever you start, and sometimes you're coming in late and trying to case for people, so you don't have as much time. But what's your process of how you get ready so you'll be ready to try that case when the bell rings?
Monty, that's a great question. I'm glad you asked that. As you mentioned earlier, I teach trial techniques on two different legal boards here in San Diego. And I always ask this question right off the bat, first class, within the first 15 minutes of all my students. When do you start preparing for trial? Oh, after the CMC or when the experts are exchanged or, da, da, da. Well, you got the TRC, trial readiness conference report. That pretty much is when I'm really preparing for trial and stuff like that. And I have to tell them, you're all wrong. Let me explain. Because this is how I was taught by Doug Walters and Phil Sharp, if you remember those
Great
names.
lawyers.
Great lawyers. Those were my mentors when I first
Yep.
started doing insurance defense. And they both taught me right off almost the first day on the job. You start trial prep the day you get the file.
Yep.
And that's as a defense attorney. As a plaintiff's attorney, you start trial prep during intake with your client.
Yep.
When they're telling you the whole story, you should be hearing their story, not talking, listening to their whole story, get their whole story out, pick up the red flag issues, pick up the green flag issues, pick up whatever. And be thinking in your head, okay, I understand his story. What will I need at trial to prove his case? And
Right.
you should start doing that during intake with your client.
Right. I mean, lots of good trial lawyers will start getting out the jury instructions and looking at them. What do we got to prove? How do we put this together right from the beginning? And that's true. I agree with you. You have to start preparing for trial from the beginning. And I think any case you take as a lawyer, whether you're applying for defense, you should only take the case assuming you may have to try it. And a lot of lawyers only take a case to settle it, but I think you get the better results if you always assume I'm going to try this case and you're preparing to try it from the beginning.
Rule number two from Doug Walters and Phil Sharp, once again, great trial lawyers themselves, was not only do you start preparation as soon as you get the file, you have to assume that every case you get is going to trial.
Yep.
That way you're working it up properly. If they throw you enough money along the way and it settles, that's all cool and groovy. But come towards the end of the game, you're not behind the eight ball or behind the curve because you thought the case was going to settle. There's no way they're going to try this. They're going to settle that.
Right.
Those are the cases that go to trials. The ones that you think, they'll never try this case
Oh,
again.
that's true.
Those are the
Well,
cases.
let's go back to the question though. When you are now in that final trial prep mode, are there some things you do that you've developed over the years that help make sure you're ready to try the case?
Yes. First off, I'm a sole practitioner, so I do all my own work.
Right.
Been literally living with these cases for a year and a half, sometimes 2 years. And
Right.
I know my clients, I know my people. I spend time with my clients. One of the Jerry Spence methods I learned from going to their regionals is you need to get to know your clients.
Yeah.
I've spent Saturday afternoons watching TV or Sundays watching football games with clients in their own living room, just hanging with them, talking to them, getting to know them. Look around their house at the pictures on the walls or trophies over here, or things that they got going, and get to know them as human beings, not as clients, but as human beings and friends.
Right.
And that is probably my final trial prep. And I'll start that usually about 2 months before trial, going to their house or let's just meet somewhere outside of my office in a neutral, somewhere in a park or Balboa Park or somewhere like that, or your home if you don't want. But if you don't want me to go to your home, we can go somewhere else or whatever. And we just sit down and we chat, we talk. And a lot of times I'll start off for the first 45 minutes. What have you been doing lately? What's going on? What's your favorite movie? Or what's your favorite, who's your sports team? Everyone's got a sports team. Who's your favorite? Just talk to them about anything except the case or the lawsuit. What I'm trying to do is let them know, first off, I'm a human being too,
Yep.
and your client's got to know that. you're not just the attorney. You're a human being too. You have a life. I share what's going on in my life with them. They share what's going on with their life. And you'd be surprised. All of a sudden they'll say, "Oh, and did, did I remember to tell you I used to do this, this, and this, and da 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 da." Or my wife, I fell down 3 weeks ago. I just, for whatever reason,
Mm.
didn't I tell you that? And, no, 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 you didn't. Tell me more. Tell me more. And so, but you find out a heck of a lot more just being a human being with these people. If you're doing lawyer with your client, question, answer, like you're taking their depo or something like that, they clam up, they shut down, and they're scared because I might say the wrong thing, I'm gonna do dumb. You started off being a human being with them. I start off in the intake being a human being with them, but right before trial, I'm spending a lot of time with my clients.
Mm.
I know the case at that point. I've taken the
Yeah.
depots. I summarized the deposition transcripts myself. I know my cases inside and out by the time I go to trial. All I need to really know at this point is fine tune my client, get him
Now,
or her.
when you were a defense lawyer, I'll bet you didn't spend that kind of time with your client because it was a different approach. But when you started doing that, representing your plaintiff clients, how's that helped you tell their story with the things you've learned over the years?
What it does is you get to know them as a human being. And when you got to talk to a jury about your client, you got to know who you got to know what to tell them, how
Yeah,
this has affected their life and
yeah,
what they did before, what they can't do now, what they have, there's what they absolutely can't do, and then there's what they can do, but they're limited. They can't do it as much or
right.
as hard or as frequently, or they do it and they pay for it for the next 2 days with pain and things like this. These are things you have to know, and you got to be able to explain this to the jury. And that's why this meeting with them and getting to know sometimes these little tidbits that you get turn out to be key factors in what a jury is buying on the injury or the damage or the harm to your client. It really is. It really is. The little tidbits.
Yeah, little tidbits can be gold,
Absolutely.
total gold. Well, let's talk about this. In a lot of people talk about themes and what they're talking about, and plaintiffs lawyers are always talking about, themes for their trial. But what kind of themes have you used over the years that you felt were pretty successful? I know it has to be case related and case specific, but what kinds of things have worked that you thought, hey, that was a good approach, good theme.
I do a lot of mainly PI, personal injury, auto cases, trip and falls, industrial accident, things
Right.
like where somebody has injured somebody else. These are my cases. My theme for the most part, probably a good 90% of the time, is what I call accountability.
Hmm.
And I explained this to the jury during my opening statement. The reason we are here in trial is because I need my client and I need to make the defendant accountable for the harm that he caused.
Yeah.
And the reason we're here is because they're not accepting accountability at this point. So we're asking you to make the defendant accountable for the acts. And accountability in a personal injury case, civil litigation, equates to money damages. Let me explain. Then I kind of go further from there.
Okay. Yeah, and that's great
Accountability is a
because
good one.
that's going to be something you can use a lot because of the nature of the cases you have. Now, you've seen a lot of different defense lawyers, and I'm sure you've seen some outstanding defense lawyers in all those cases. Have you heard any good themes from the other side where you think, damn, that's a pretty good theme? Um,
Some of the better defense lawyers will concede on the points that they should concede on,
mhm.
but then find that one or two little hitch in my case that they focus on, and they turn the whole case into the one or two little hitch. 4 month gap in treatment. Well, he must not have been hurt. if he's not treating, he must not
Right.
have been hurt, or maybe something happened during that 4 months, ladies and gentlemen. We don't know, but maybe something happened in that 4 months where, that causes injuries and why it's still going on and stuff like that. And I've seen those be very, very effective. So you've got to be able to explain things like gaps in treatment,
Yep.
or whatever the issue might be. As a plaintiff attorney, I have to beat the defense lawyer to the punch on the hitches in my case or the hiccups in my case.
Yeah.
If I do that, the jury gets it. They understand, okay, yeah, 4 months he didn't have treatment. Thought he was getting better. Then it flared up again. People understand that. Do you know what I mean?
Right.
They're human beings. Everyone's had that issue where back hurts or side hurts or neck hurts or knee hurts, and then a couple months later it goes away, and they're thinking, oh, I'm cool and groovy again. 6 months later it comes back again. People understand that. When you explain it in that way, they get it. You know what I
Right.
mean? But I've seen some good defense lawyers really make some good ground, make that jury start taking notes from them and start, thinking, and, if you're focusing on the jury, which you should be,
Yeah.
is, because we can't communicate with them. It's all about their body language and their facial expressions. So they're
Right.
telling you a lot about what they're thinking and where they're going and what you need to either hit harder on or back off on.
Yeah. And what you've learned over the years, every case has good points and weaknesses. And you got to be willing to talk about your weaknesses and bring them out. And like you say, explain them. Because if you don't talk about them and you let the defense talk about them first, you lose all kinds of credibility, and that's going to hurt you in that courtroom.
You know what it's like going to trial in El Cajon? My client was a black man. He was 52 years old. He was out of prison for 5 years after doing a 15-year sentence for cocaine sales.
Mm,
And the judge was going to let that in.
yeah,
Do you know what it's like talking to the jury about that? You have to just lay it out. You have to
yeah,
lay it out. Ladies and gentlemen, I got to let you know right off the bat. My client is a convicted felon. In 1985 or whatever it was, he got caught selling cocaine to an
yep,
undercover agent. He was convicted. He was tried. He was convicted. He did 15 years or 10 years or whatever it was in prison. He's come out, and in the last 5 years that he's been out of prison, he started his own company. He hires ex-cons that are living in halfway houses to do his construction cleanup. He bought a pickup truck and he cleans up construction sites, and he hires ex-cons that live in halfway houses, picks them up in the morning, takes them to the job site, has them back before dark, just as they're supposed to be, and he's totally rehabilitated his life. And you explain it that way, and all of a sudden, that
it's
felony conviction ain't that big of a thing.
yeah, it's not that big a deal. That's right. But you gotta talk about it. So now let's go to a question I love to ask everybody, and I know you have an opinion on this. So, in your opinion, based upon your experience, what's part of the jury trial is the most important and why?
You're probably going to get this from a lot of your speakers on this, but the same thing. But for me, it's jury selection.
Yep.
You win or lose your trial in jury selection, believe it or not. My goal is to send 10 friends into that deliberation room, not or 12 friends into the deliberation room, not 12 strangers. So jury selection is the only chance we've got to do that. The whole goal in jury selection is to connect with that jury. You, the attorney, connect with that jury. I find that 50% of the juries will cast their vote for one side or another based on what I call the popularity quotient.
Mm,
If they like you and your client, you can have bad facts, bad case, they'll rule in your favor.
right.
You can have the most stellar case going, no hiccups, no hitches whatsoever. But if they don't like you or your client for whatever reason, you get this much. Okay. So jury selection is the most important. That's where you connect.
Right.
And I have a shtick that I do with jurors that is a little different. I see defense attorneys, for the most part, are really weak in jury selection, mainly because we go first. Plaintiffs
Right.
go first.
Right.
And a lot of good stuff has already come out. So you see defense attorneys all the time say, now, will you be fair and impartial? Will you be fair and impartial? Will you be fair and impartial? You understand that I go second. You have to wait till all the evidence is and da 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 da. They're going 10 minutes into a spiel during their jury selection, where I've had to say, judges, there going to be a question coming here or not? Or, this isn't
Right.
open. This isn't closing. Yeah, ask a question, counsel. But you got to connect with that jury. Defense attorneys ask what I call the idiot questions. Will you be fair and impartial? You can line 10,000 potential jurors up in front of a judge, make them raise their hand, and have the judge ask, will everybody here be fair and impartial? They'll all say, oh, yes, we'll be fair and impartial.
That's a worthless question.
Worthless. You get no ground out of it.
Everybody's going to raise their hands and say, of course we will.
Of course, will. So here's what I find with jury selection. First off, the 32 that you get on the panel come in, first 12 in the box,
Yep.
in the rows in the gallery, as we all know, and whatever. And they're sitting there like this, back in their chair, arms crossed, legs crossed, looking down, won't look you in the eye, just giving you that noise.
They come in skeptical.
They don't want to be there. This screws up their whole week. They got to rearrange their whole whatever they got going on. Downtown sucks. One-way streets suck. Parking is like $40 a day now. If you could find parking within a half a mile or a mile of the courthouse,
Right.
the whole process for them this is a pain in the butt. So after going through many trials and trying to get through these people, sometimes you can, sometimes you can't. I understood that I got to get them to go from like this during my jury selection to like this. What? That's my goal. If I do that, I know I've connected. Okay. And I started off with a different shtick. And I've been doing this since pretty much 2007 or 2008 when I first kind of popped into my brain. I first say, welcome to Department 72 or 66 or wherever we're at. This is going to be a way easy trial, ladies and gentlemen. We'll be out of here. We'll be done with the evidence by Thursday. You'll be deliberating and hopefully have a verdict by Friday. So I got you for 1 week, and I guarantee you we will do our best to get you out of here even sooner if we can. Because the main thing they're all thinking about is how long am I going to be here? I want to get that off their mind.
They like that.
They like that. And then I go into it, I said, now, let me ask. About 30 days ago, each of you got a letter in the mail. Looks something like this. I hold up an envelope, letter in the mail. Before you opened it, you knew what it was, right? And I shake my head, I'm going like this. You knew what it was, right? And they're all kind of going, yeah. It was a summons for jury duty, wasn't it? And they're all going, yeah. The arms are coming down. They're nodding their heads. They're looking at me. You know what I mean? These are all good signs. And I said, who here was thinking, dang, jury duty, before they even open that envelope? All 32 hands just shoot up straight like this. Judges hate it when I do this. They really don't like this because they know I'm looking for cause,
Yeah, right.
And challenges for cause, And I said, okay, Mrs. Smith, what was your dang moment? And she's, I've got a 12-year-old and a 14-year-old and a 16-year-old, and the 16-year-old got a car, but he can't drive the other kids around. I got to shuffle the kids, 3 times a day to this, and this, and da 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 da. And I just don't know how I'm going to do this. And I got to be here till 4:30 every day. So, wow, Mrs. Smith, I understand. I've got 2 kids of my own that are, high school level at this point, and I fully understand the shuffling around stuff. My wife is like part-time this and part-time taxi driver. I got it. But are there any other like moms that maybe you picked up their kids or taken their kid, once or twice because they had something they had to do, somebody that can kind of fill in for you and get your kids in places? Well, yeah, I can probably make some calls. I said, good, because we really need jurors here that can fully focus on the testimony and the witnesses and the evidence that comes in. We really need that. And if you're going to be just freaking out in the afternoon about how Susie getting to ballet or Johnny getting over to softball or baseball or whatever like that, you won't be able to focus on my case. And if you were my client or even the defendant sitting over at the other table, you'd want a juror that is going to be fully functional and fully focused on the case. Can you do that, Mrs. Smith? If you can't, you need to let us know right now and explain why. But if you can make some arrangements like that, that's always a good thing because we'd like to have you here. And you tell a juror, I'd like to have you here. Yeah, I think, Mr. Babbitt, I'll be good. I'll be good. I'll get it taken care of. I'll get it taken care of. Thank you, Mrs. Smith. Thank you. You know what I mean? And I'll go through like 3 or 4 of these people like this. What was your dang moment? What was your dang moment? Stuff like that. Then I do another approach. I shift gears and I go, how do you guys feel about the legal system? And we see everything in the papers and the news about this trial and that trial, and don't know whether it's a criminal trial or a civil trial with money or whatever. How do you guys feel about the legal system? You always get about 4 or 5 hands pop up. Legal system is jacked up. It's wrong. Back in the days after the McDonald verdict in the early 200s. Yeah, and that woman that spilled coffee on herself in McDonald's, she got like $500 million, for spilling coffee on herself. Well, I'd ask that person, I said, how did you hear about that McDonald's case? Well, I saw it on the news. So a newscaster reads off a teleprompter, like about a 15-second blurb about the case, right? Well, yeah. And that's all you know about the McDonald's case, right? The end result. Well, yeah. And I go, are you aware that trial lasted 6 months? There were over 15,000 documents introduced and close to 150 witnesses that appeared in that trial. And that jury had to listen to them all and examine all. No, I didn't know that. Well, who are you blaming for that jury verdict? Who do you blame, for that 500 million? And it wasn't that much, man.
Right. It wasn't that much.
It wasn't that much, but, it was a high amount. But what do you, well, I blame the lawyers. Really? Why do you blame the lawyers? Well, because, it was their case and their ones, and all of a sudden they start stalling. I said, do you understand it was that same jury that sat there for 6 months, listened to all the witnesses, reviewed all the documents, heard every piece of evidence, unlike the news guy that you just heard that from, when the 15-second blurb, that everything. And then they spent 3 months deliberating, going through everything again before they reached their verdict. Did you know that? No, I didn't know any of that. Does that make a difference now? Well, she goes, well, yeah, I guess it does. I said, well, are you now shifting your blame from the attorneys to the jury? Oh, no, not the jury, not the jury. I said, because here's the deal. If you're impaneled on this jury, ma'am, you are the legal system. There's only 3 things that this country can force us to do, whether we want to or not. Does anybody know what they are? Somebody always blur out, pay taxes. Boom, number 1. How about the other 2? Everyone draws blank. No, and they're just sitting there looking at me. Tells me time to offer up. Said, pay taxes, military service during a time of war, and jury duty. That is how important jury duty and our justice system is to the bedrock foundation of our Constitution and our country. We don't burn down people's houses when they wrong us anymore. We don't go and do vigilante stuff. We don't, do this, or at least we're not supposed to. When we have a dispute with somebody, we take them to a court of law. We make our complaint. We bring in a collective body of the community to decide 4 things: who's right, who's wrong, how little, and how much. Mr. Jones, can you do that? Yeah, I can do that. Good, that's what I wanted to hear. Mr. Zemkowski, can you do that? Yes, I can do that, Mr. Babbitt. Yes, I can. Now I'm doing what I call empowering them.
Yeah.
First, I'm letting them know I'm a human being. Downtown sucks, parking sucks, you don't get paid for this, your whole life's good. I'm a human being. I understand. I got it. I got it. I'm with you. Then I go into, their potential biases of the legal system or claims attorney. I let them know, I said, we need fair and impartial jurors, just like you would want if you were a plaintiff or a defendant. The defense attorney, as well as myself, we both want to start off this trial on an even playing field. If either one of us are starting off a step or two below in your mind because we're a plaintiff or we're a defendant or a past history thing that you might have had or whatever like that, you're the wrong juror for this case, and you need to let us know. And if you don't want to let me know, you can ask to let the judge know in private. So you know, this is what we expect of you. This is how important this is to our society, that we get good, fair jurors that listen to the whole thing, and that both sides are starting off on a level playing field, just as you would want if you were plaintiff or the defendant. And that's how I kind of drive that home to them.
That's great.
At this point, I've connected with these people.
Yep.
You know what I mean? If I can talk about one connection story real quick, and it's a short one. I'm doing a trial in El Cajon, Judge Sturgeon's last trial in El Cajon. Eddie Sturgeon is probably one of the best trial judges I've ever been in front of.
Great one.
And I had a black man who was in El Cajon. I had a defense attorney that was just like that guy out of Stockton, just hardcore, fought on everything. I was brought in 3 months before trial to try this case. This was the guy that was a convicted felon for the cocaine stuff like that.
Yep.
And judge does his 8 questions to the jury, what's your name, what's your occupation, what do your spouse do, kids do, da da da. Yeah. Well, can you be fair and impartial? He said, Mr. Babbitt, would you like to voir dire? Yes. Well, this one woman on voir dire, she was probably mid-40s, a little short. I remember her perfectly, a little short, a little chubby, strawberry hair, colored hair, strawberry blonde hair, I think they call it. It's not blonde, it's not brunette, it's that, and freckles all over her face. Cute little woman. And she had told the judge that her and her partner give swim lessons to children at the Santee Community Pool. Now I get up, and this is in my point where I'm really focusing and trying to establish ways to connect with these jurors personally.
Right.
And and I'm thinking, God, how do I connect with this woman? What do I have in common with her that I can connect with her? And I just started off. I said, ma'am, I understood you told the judge that you and your partner give swim lessons to children at Santee Community Pool. She said, yes, we do. How long have you been doing that? Well, about 5 years now. I said, what was the path that led you there? Nobody grows up saying, I want to give swim lessons to children at the Santee Community Pool. What was the path that led you there? Now, that's an open-ended question that gives a person an opportunity to tell me their whole life story if they want.
Yep.
And people love to talk about their life story and their accomplishments and how they got somewhere. I mean, the hardest part during jury selection is getting these people to open up. Remember, they start off like this, you know what I mean? And getting them to open up and uncross and is tough. And this is what I focus on. So she says, well, long story short, my partner and I, we weren't partners at the time, but we met at swim lessons for our kids. She's got 2 kids about the same age as my two, and we met there, and we were talking about how expensive they were, and she was on the swim team in high school, and I was a lifeguard at my college, at college at the pool where I went to college, stuff like that. And we thought, geez, we could do this, and so we both got certified and training, and we cut a deal with the Santee Community Pool, and we've been teaching swim lessons there for the last 5 years. She goes, that's great. I said, that's great, that's great. And she goes, and my partner, same partner told me a lot back in like 2007 or whatever, probably a little bigger issue than it is now. America's adjusted to the gay lifestyle. And she says, my partner, we weren't partners at the time, but her marriage was going bad. My marriage was going bad. And we got divorced and we got an apartment together because our kids knew each other and it was just easier. We could help each other pay rent. And then things just kind of developed. As soon as she finished that, I said, That is a wonderful story. This is one of the best parts of my job is I get to hear about people like you know, and find out your walk in life and how you've done things. I love this part of my job. I really do. I said, but let me ask you one question, ma'am. She goes, sure, what's that? I said, and these are things that just pop into your head when you're doing a board hire because there's no
Right,
prep for board hire. You don't know who's
right.
coming. There's no prep. You just have to do it.
You
You
don't know what's coming up.
know what's coming up. And I said to her, I said, let me ask you one question though. You ever get that one kid swims back and forth in the shallow end real good, but is still afraid to go into the deep end over there because it's deep? Oh yeah, I still get that kid. Do you ever do to them like my dad did to me when I was 5 years old? Just threw me in the deep end and hope I make it to the side. Everyone kind of chuckles a little bit, just like you start to smile a little bit. Everyone kind of chuckles a little bit. Oh God, no, we can't do that. We have techniques. We hold their little hands. We swim backwards, and we make them feel comfortable. Blah, blah. And she just finished telling me that story. I said, I always thought that if my dad hadn't done that to me when I was 5, I probably could have done something with my life other than being a lawyer. At that point, I got, yes. See, Monty, you're laughing, you're cracking up. I got the bailiff spitting coffee out of his nose. I got Judge Stevenson's head going down like this, slamming the desk, laughing and cracking up. The whole jury panel's cracking up.
That's great.
My question to you right now, Monty, is did I connect with that jury panel?
Of course you did. Yeah.
The epilogue to that is the next guy was an astronomy professor from San Diego State for 25 years. I said, now I'm lit at this point. I get lit during trial. I'm that guy that gets lit, like kind of like I'm getting right now. And then, Mr. Jones, I said, you're next. You know where we're going with this, right? He goes, yeah, but I think I'm going to surprise you, Mr. Babbitt. I said, okay, let's get this started. I said, you're an astronomy professor the last 25 years at San Diego State, right? Yes, that's correct. I said, it's July 1969. You're watching a black and white TV with your family, and you see Neil Armstrong land on the moon. Ever since then, you wanted to be an astronaut, right? And he goes, this is where I got you. I knew you were going to go somewhere like that after I saw what you did with the other woman. I knew you were going to go to that. This is where I got you. Nope. I was always really good at math and physics. I got a, cum laude, BA degree in mathematics and physics, a joint major at Cal Poly Pomona, and then I went on to Cal up in Northern Cal. I got a master's there. Went on over to MIT and got a PhD in astrophysics. Wow, impressive, sir. Very impressive. And he says, unfortunately, NASA was shutting down during those period of times. There's no funding for NASA, and with an astrophysics PhD, all you could do is go work at NASA, which was my goal. And I saw an application to be an astronomy professor at San Diego State, and I needed the cash, and I put in my application. Been there 25 years now. I'm head of the department. I said, awesome stories. I love these stories. I wish I could do every one of you right now, but we don't have that time for that. But thank you very much. But I got one question for you. Just kind of like I did with that other one. He sits back and goes, oh, here it comes, right? It's not that bad. I go, if you had a shot to go on the space shuttle up to the ISS station circling the Earth, would you take it? He goes, in a heartbeat. I go, see, I wasn't that wrong after all. Sorry. Everyone's laughing and cracking up. Now, I
That's
did
great.
have 4 people that I kind of questioned, not so much in depth or, da da da. I knew I had that jury at that point.
Yep.
It was a good jury.
Yep.
Da, da, da.
Those are great stories and great examples of how to connect with the jury. So let's do this because the time goes by so fast,
I know.
Skip. We're getting close to where we're going to have to bring her home, but you've connected with the jury, you've got a good jury, and now you're going to do your opening statement and your direct exams and your cross exam and the final arguments and all that kind of stuff. I know voir dire is the most important. That other stuff you're going to do during the trial, what do you think is the next most important?
When you have complex medical issues, you got to train your doctors, your experts, to talk to the jurors in non-medical terms. I
Oh
think
yeah.
this is key. This is key. I meet with my experts and I tell them, I go, look, this is not an insult to anybody, but when your role is not to advocate. That's my job. Your role is to educate and inform that jury as to the
Right.
injuries, the extent of the injuries, the causation of the injuries, and the sequel of these injuries to my client. And I need you to do that in your explanation when I ask you questions. You talk to that jury because I want you looking at the jury when you're answering questions. Don't look at me. I want you looking at that jury because they're the ones that need to know this. I already know the answer. But you've got to talk to them, assume collectively they've got a 12th grade education and they were
Yep.
students,
Yep.
C-level students, 12th grade. And I'm not saying talk down to them, but you need to use, good example, sir, is we don't use words prior and subsequent. Use before and after. The last thing we want is a juror for 30 seconds. Okay, prior, is that before or is that after? Because some people are that attuned. So
Yeah, I've preached about that for years.
you
Yep.
use simple terms. You use
Right.
simple things. You know. Real quick, I early in my career I had a neck straining injury case, and I'm trying to be all professional. And the doctor, cervical strain, cervical strain, cervical this, cervical that, cervical da 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 da. End of the trial, I did okay. It was great. One of the big trial thing. I think it lasted 3 days. The juror comes up to me, and he was about 75, 80 years old, and says, "Mr. Babbitt, can I talk to you for a moment?" Sure, sir. Trial's over. You can talk to me. He goes, "How come you kept talking about that woman's genitalia the whole trial?" I didn't understand that part. Now, that told me volumes. That told me volumes, Monty, that you use cervical without explaining where cervical is because not everybody knows.
Right.
Thoracic's even worse. A lot
Yep.
of people know cervical and lumbar. Thoracic's even worse. They don't even know where that part is. They think that's inside your chest cavity or your heart
Right.
or something. So you've got to use simple terms. And and that means sometimes you get your expert on there. I'll stand up and I'll say, "Okay, doctor, we're talking about straining injuries to the cervical spine or the neck, right? Yeah, the neck, the thoracic spine, which is the mid back, right? Yeah, and the lumbar spine, which is the lower back, right from the belt, right above the belt line to about where your butt crack is, right? Yeah, exactly. And I'll stand up and I'll point to those areas of my body, to the jury when I'm going cervical, thoracic, lumbar.
Right.
You need to give that jury visuals, either through your own body language or through blow ups or through, something on the
Right.
elbow strains and Monty, I don't know about you, but I'm not that far away from using foam core blowups in my jury trials. I mean,
Yeah.
yeah, I go to the computer and stuff, but I'll still occasionally use a foam core blow up, and stuff like that. But you've got to give that jury visuals in your presentation, whether it's just through your words, because words give visuals. That's what language is. Language is giving sounds that give a visual image inside a person's brain.
Yeah. What I say about that is you have to create word pictures.
Perfect. I love that. I love that. I love that, Monty. I love that. That's what you got to do. If you're just doing a rote question, answer, question, answer, question, answer,
Yep.
just fall asleep. They
Right.
don't, you know,
They
with
don't get it.
you
Well,
got to
one of the
keep
thing I found with doctor experts, and this can be very important, is you got to make sure you educate your expert about the standard of proof in the law, because in medicine, they live in a world of you have to be 100% certain to say something, whereas that's not the law. And you got to educate them to realize you don't have to be 100% certain. If you got an opinion to a reasonable medical probability, that's good.
That's good.
You got to teach them that. Well, Skip, there's a million more things we can talk about. Our time is running out pretty soon, but let's finish off with this. You've shared with a lot of people over the years, taught a lot of people, and you've got great information to give, which you shared today. What advice do you give or would you give to a younger person who wants to become a trial lawyer? Maybe something you learned when you were younger from your mentors, maybe something you've learned along the journey. What advice do you have?
Get in the trench and do it. Every single trial makes you a better trial lawyer, and it starts with trial number one. Assume you're going to make mistakes.
Yep,
Assume this is a learning process, and it's not a bell curve. This is straight up, man. It is vertical. You know? But you got to get in. You
it
got to get
is.
in the trench. You got to fire the gun. You got to move. You got to shake. You got to do it. Nobody puts on their business card settlement lawyer. You know,
Yep,
you know, if you're a personal injury lawyer, you've got to be a trial lawyer because if you're not, the insurance companies know who tries cases and who doesn't. They know, and that's how they calculate how much they're going to offer you or whether you're going to take it. They know who rolls over and they know who fights it. Yeah, I get called at this point by other attorneys to go to mediations with them, just to go to a mediation with them and
yep,
skip the mediation so that we can tell the mediator if this case doesn't settle, Skip's going to try this case for
yep.
you. Okay. I probably do this once, twice a month now, you know, and the mediators are kind of getting it. And what does the mediator do? It goes back to the defense attorney who knows me and the adjusters who know me. Skip's going to try that. Skip's in the other room. What's Skip doing in this case? He's not associated in. No, he's just sitting in, and the case doesn't settle. He's going to try it. Boom. Next thing they're jumping up 100% on their last offer, and
That's right.
so there might be room for more. That's what you get when you've been an accomplished trial lawyer. Okay. If if you don't try cases, you don't get that. You get the low ball offers, and they don't work.
And you have to try the cases. You can't learn just by reading in a book. You have to be in the courtroom. You have to be in the moment. You have to react on your feet. You have to make mistakes, and then you learn and you get better. And everybody's terrible their first few trials, and everybody gets better with the difficulty of experience.
Monty, I could write a book on trial experiences where a juror died in the jury box during one of
Yeah.
my trials. I had another juror have a full-on seizure during my opening statement. I had
Wow.
another juror just get up and walk out of the courtroom during closing arguments. I've had some weird things. I had a judge, the Stockton trial, the judge fell asleep in the middle of the trial in the afternoon. One of those noises, and jury's kind of giggling and laughing. I got a good cross going on one of the defense experts, and all of a sudden the judge is back there snoring, and the clerk doesn't notice. The bailiff's reading his Guns and Ammo magazine. He doesn't notice. The jurors all kind of pointing and laughing and giggling. First question that popped into my head at that point what are my ethical obligations as a officer of the court if the judge falls asleep? What do I do?
Right. Right.
And I tell this story to my students because you have to do something. You
Right.
can't keep questioning or sit there. You have to do something.
You have to do something.
So I just looked at the jury, held up my finger like this, like watch, kept my questioning going, slowed it down, picked up a stack of deposition transcripts, slammed it down on my desktop as hard as I could. Judge wakes up, read back that last question. Everyone starts laughing and giggling and da da da. He's okay. You caught me. Let's just take our afternoon break a little early. We'll get some water, da da da. And, you let the judge off the hook for that too, and whatever. And jury seemed to like it. I'm sorry, my fault. That was the wife, but I'll take it.
Hey, well, that's all right. Tell you what, Skip, now's a great time for us to finish our discussion. Has been delightful. Thanks for sharing all that you've learned, and we haven't covered everything, but we've covered a lot. Thanks for all that you do in the community and all that you do for your clients. Keep doing your good work, bringing justice to people who need it. So thank you very much for being a guest today.
Bonnie, I've known you for at least what, 30 years at least,
40 probably.
probably 40, whatever. We've had cases against each other when I was a defense attorney and you are a remarkable individual in and of yourself, sir. Thank you for this opportunity. I very much appreciate this, and I feel honored that you asked me to do this with you. Thank you.
Thank you.